we'll get started. I've been asked to call one case out of order before we begin with the remainder of the calendar, the Ruggs matter.
Good morning, Your Honor. David Chesnoff and Richard Schoenfeld here on behalf of Mr. Ruggs.
And you are confirming on behalf of Mr. Ruggs?
Yes, we are, Your Honor.
We'll note the confirmation. This is the case of the State of Nevada versus Henry James Ruggs III, case number 21PC050378. Are you Mr. Ruggs? Mr. Ruggs is present in custody. Mr. Ruggs is here because of an arrest on November 2nd of this year for driving under the influence resulting in death and reckless driving resulting in death, 2 felony offenses. I did review before court a temporary custody record, an arrest report, Nevada pretrial risk assessment tool, financial affidavit, criminal history, and other statutory factors. I did find probable cause for the arrest. I'll note that Mr. Ruggs is currently being held without bail, which is standard on this type of charge. I note that I did receive a number of media requests. I've received 9 media requests. Those will eventually be provided to counsel if they haven't already. I also wanted to note for the record that I did receive a phone call yesterday from defense counsel, Mr. Chesnoff. It was explained to me it was with permission of Chief Deputy District Attorney Eric Bauman, who's present in court. It was simply to retrieve my email address. I did receive an email from defense counsel. I received attached to that email defendant's motion for a reasonable bail setting. Has that been provided to the state?
It has, Your Honor.
All right, thank you. I did review that and those other items, and I'll next hear from Mr. Bauman the state's position on Mr. Ruggs' custody status.
Thank you, Your Honor. For the record, Eric Bauman for the state, bar number 9755. Your Honor, as you mentioned, the incident, the crime and its tragic consequences took place yesterday, approximately 3:39 a.m. northbound Rainbow Boulevard, just south of Spring Valley, which I note for the record is a residential area. Defendant was traveling at beyond an excessive rate of speed. Eyewitnesses put the defendant at over 100 miles an hour. We were able to confirm through investigation, through a download of the airbag control module from his vehicle, that at 2.5 seconds prior to impact, he was traveling at 156 miles per hour, northbound on Rainbow Boulevard. I would note that in my 24 plus years of prosecuting vehicular crimes, that is the highest speed I have ever heard of in an incident like this. At the point of airbag deployment, the vehicle was traveling at 127 miles per hour. I would note further that through investigation, there was a loaded firearm found in the driver's floorboard of the vehicle. Defendant's vehicle struck the rear of the victim vehicle with such violent force that it ignited the fuel tank. 23-year-old female occupant and her dog died as a result of the fire caused by the crash. Furthermore, we anticipate filing a second count of DUI causing substantial bodily harm as a result of injuries to defendant's passenger. Defendant was argumentative and uncooperative with both police and medical workers throughout the investigative process. However, a search warrant was obtained. Blood was drawn from the defendant within 2 hours of the time of driving. His blood alcohol level was measured by the Metropolitan Police Department Forensic Laboratory to be .161. Within 2 hours of the time of driving, that is more than twice the legal limit. Furthermore, I would note that at that blood alcohol level, he was also, under the laws of the state of Nevada, illegally in possession of a firearm. I would note this is particularly tragic. Since 2013, the National Football League Players Association has contracted with various rideshare services, specifically to provide free ride shares availability to their membership, specifically to prevent tragedies such as this. Now, in consideration of bail, I would note for the court that the defendant is facing significant mandatory prison time. Under the charges we anticipate filing, there's a maximum of 46 years in the Nevada State Prison to which he's exposed. Based upon the evidence gathered and analysis done thus far, I can represent as an officer of the court that the likelihood of conviction is high. Based on defendant's reckless, wild, and out-of-control course of conduct that already has resulted in the loss of human life, the defendant has established that he is a danger to our community. Any release should be conditioned on high-level electronic monitoring, surrender of defendant's passport if he has one, a strict no driving order, and 24/7 alcohol monitoring. Finally, I would submit that the court should consider the defendant likely has significant financial means at his disposal to post bail. For these reasons, the state is requesting bail be set the amount of $1 million with the previously mentioned release conditions. Thank you.
Thank you. And I will next hear from Defense Counsel, Mr. Chesnoff.
Thank you, Your Honor. As the court knows, the purpose of this appearance at this point in time is to determine the conditions of release, not to argue the merits of the case, although the facts of the case are one factor for the court to consider. The court knows that bail is not punishment. If there is ever going to be punishment, that's for another day. What we have, Your Honor, is a young man who has never been in trouble before, from what we understand, never a traffic violation. He has consistently followed rules and regulations. He played for a major Division I national championship football team, followed all the rules, and was an excellent teammate and player. The same applies to the scrupulous investigation that the NFL does when deciding who's going to be in the league when teams draft. His background is impeccable. When he came to Las Vegas, Your Honor, he immediately contributed to the community. He's been working with 3 Square. He works with charities at home in Montgomery, Alabama. Comes from a very close-knit family, has 5 brothers, never been in trouble. We have no quarrel with the conditions that the state is recommending, save and except for what we believe would be an excessive bail amount. The state just commented that he has financial resources. The court may not be aware, Mr. Baumann may not be aware, but he was released by the team. So the substantial financial worth that Mr. Baumann is referring to is now in question. The real question for you, Your Honor, is will he come to court and will he pose a danger? The conditions that have been proposed by the state significantly and sufficiently cover that. The question of the monetary is equally covered by the surrender of the passport and the home confinement. We asked in our papers, which Mr. Baumann has received, for a bail of $150,000. We would point out to the court that most recently, a policeman who lived out of state in Connecticut was granted a bail in a similar circumstance for $100,000. We think perhaps because of the publicity that's attendant to this, the district attorney is trying to send a message. That's their prerogative. But Your Honor's job is to decide what is a fair amount to guarantee his appearance and to guarantee that he is not a danger. It is not to inflame, which is what is occurring. What we need to do, Your Honor, is have a reasonable bail, as we've suggested, of $150,000, which is very high in these cases. Your court knows we've been involved in other situations where the bail has either been similar to that or slightly higher. It is, in my 40 years of experience, this request for $1 million is very excessive. We've pointed out to you his entire history, and we ask you, Your Honor, to balance what the state is asking for and our suggestion and make a reasonable setting. $150,000 is that reasonable setting, and we leave the final decision as to the amount to the court.
And I did want to follow up with you on that, counsel. I did receive a financial affidavit. So Mr. Ruggs has been interviewed by the Pretrial Services Division of the Las Vegas Justice Court. He did fill out a financial affidavit. There was very little information other than his employer as the National Football League, as an NFL player. Looks like one child, a 3-year-old, a local address. He did not list an income. You mentioned he's been released by the team, so I believe we do have a representative from the National Football League here today. I don't believe I need to hear from that individual. But you indicated he's released from the team. What is his status with the National Football League?
My understanding is he's been let go by the Raiders, so he's no longer employed.
All right. Thank you. There's a number of factors that this court needs to consider in this case. The state has indicated they are filing additional charges that is consistent with my review of the allegations contained in the arrest report. The state's indicated they're adding a charge of DUI resulting in substantial bodily harm for the passenger. There was reference in the arrest report to injury suffered by the passenger here. The state indicated that a 23-year-old female is deceased as a result of this incident, and a dog. The dog was not mentioned in the arrest report. This is the first time I'm hearing about that. The arrest report did indicate a very reckless behavior, over 100 miles an hour in speed. The state indicated that this speed reached 156 miles per hour. The Chief Deputy Mr. Baumann indicated that's the highest speed. I cannot recall a speed that high in my career on the bench. The states indicated there was a firearm. There may be additional charges arising out of possession of a firearm while under the influence. The states indicated the potential penalty here, which is significant. If convicted, he would face, Mr. Ruggs would face a mandatory prison sentence in this case. I believe the DUI resulting in death would be punishable by 2 to 15 years in custody in prison. The reckless driving, I believe, is punishable by 1 to 6 years. There's these additional charges that the states mentioned. The state mentioned in their arguments the potential maximum penalty here. So that is a definite consideration, the reckless behavior, the allegations, the potential penalty, the very serious nature of this charge. I have to take into consideration that at the age of 22, Mr. Ruggs does not appear to have any criminal history whatsoever. This does appear to be his first arrest. So no conviction, no arrest history, no pending cases, no failures to appear. He has hired counsel. The counsel has submitted documents indicating his ties to this community, and I'm referring to the filing right now. His charitable contributions to the community. He does appear to have verified stability factors. Pretrial services did verify local contacts. Taking all of this into consideration, some higher level of release conditions is necessary. I am requiring a financial condition of release. If he is able to make that financial condition, I am requiring the highest level of release conditions. I am setting a financial condition in this case in the amount of $150,000 cash or surety. If that is posted, Mr. Ruggs is ordered to the custody of the Las Vegas Metropolitan Police Department electronic monitoring program, the highest level of electronic monitoring. Additionally, he is ordered to abstain from the consumption of alcohol, controlled substances, and any prohibited substances. I am ordering a SCRAM monitoring device be placed on his person in order to ensure compliance with that order before his release. He is ordered not to drive. He is ordered to surrender his passport to defense counsel until further order of the court. Now, Mr. Ruggs, I have set an amount lower than what the state is requesting. If you are able to post that amount, you are ordered onto the highest level of electronic monitoring. You must fully comply with all guidelines that this court has ordered today and any guidelines that the Electronic Monitoring Division of the Las Vegas Metropolitan Police Department that they may give you. If you fail to comply with any conditions of release, you're very likely to be returned to custody in a number of ways. The bail bondsman may, if you post it through a bail bondsman, the bail bondsman may return you to custody if you're not complying with conditions of that individual's release. If you're not compliant with conditions of release, the Las Vegas Metropolitan Police Department Electronic Monitoring Division has the authority to return you to custody. If you're violating any conditions of release, the SCRAM Monitoring Division will notify the court of that. The court may violate your release, may revoke your release. You must obviously stay in contact with your defense attorneys, make any necessary court appearances. Again, if you fail to do these things, that would revoke your release. A warrant for your arrest could issue. With charges like this, you almost certainly would not be given another opportunity to proceed out of custody. Please treat these conditions quite seriously. Do you understand all the conditions of release, Mr. Ruggs? Right. With that, counsel, we can set a 2-day return date, or we can set a standard 1-week return date. How would you like to proceed?
1 week, please, Your Honor.
1 week?
Yes.
All right, we'll set a 1-week return date. If Mr. Ruggs is able to meet these release conditions, he's ordered to be present at this next court.
November 10th, 7:30, J.C. Department 13.
Thank you, Your Honor.
Thank you.
Your Honor, thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Baumann.
Sure.
be a moment.